Hey guys, my name is Joel Williams. I'm a trial attorney in Kennesaw, Georgia, and I'm really happy today to have a special guest with us for this video, Marc Howard, who is a partner with Pope & Howard in Atlanta. I brought Marc in today. He's going to give us some insight onto some rather technical medical malpractice issues. I do some medical malpractice, but when I have questions about things that are kind of out of the ordinary, or if I need some extra help and special help with medical malpractice cases, Marc's the man, and I give him a call all the time. So with that being said, the first thing that we want to talk about with medical malpractice cases are known risk and complications that can arise with procedures, and how that may affect your ability to bring a claim if something goes awry with a surgery or a medical procedure.
Thanks, Joel. Really appreciate it. I think one of the first things that people need to know about medical malpractice cases is that they're a negligence case just like any other case. But because of the specific nature of things that have to be proved in a malpractice case, there's a lot of landmines that are there for someone who hasn't handled a case on a regular basis. And with a known complication, that's one of the things that comes up very often. In a medical malpractice case, the defense often approaches a case by saying, hey, this is something that we knew was a risk going in. And we're not magicians, we're human beings, we're doctors, and things can go wrong even when you do everything right. And we even have you sign a form ahead of time saying that these complications could arise. And so why are you suing us just because what we told you might happen actually happened? Well, the way we try to approach these in medical malpractice cases is to put it back on the doctor. If you knew that there was a known complication and you knew that there was this possibility of danger, then actually you should have a heightened sensitivity to that, and you should be more aware of the fact that something can go wrong, and you need to be especially aware of the symptoms that might arise from these known complications so that you can address it in time to save a patient. And I brought with me some boards that we've used at trial to show how we approach this particular problem in medical malpractice cases. And one of the ways we do it at trial is what we call an equation board. And you lawyers may be familiar with this in other contexts, but the way we present it at trial is to say, yes, there's a known danger, and the doctor has said that that's their defense. And we would do this in opening statements. We say known danger plus the important ingredient of the failure to evaluate evidence of a known danger then leads to harm. And so we embrace the known danger, but then we let the jury know of the added element of the fact that the doctor is ignoring the known danger. And I brought an example of a case we handled a few years ago, went to trial in DeKalb County. And in that case, it was a laparoscopic procedure, which is where a doctor might enter a patient through a hole, either the belly button or a hole that's made in the belly. And in this case, our client's wife was having her ovaries removed. And one of the things that the doctor knew about going in was that she had had prior surgery, and there were things called surgical adhesions. So this was a known risk, a known complication, and his defense, and what happened was he made a hole in the bowel while he was cutting in there. And he said, well, that's a known complication. Well, you even signed a consent form showing that holes in the bowels are something that happen quite frequently. And we said yes, but because you had to deal with all these surgical adhesions, you should have been extra careful, and even though it was a known complication, you should have slowed down, and then if something went wrong, you should have been on alert if something happened out of the ordinary.
Gotcha. So even though something may be a known complication and that may happen, after it happens, there are certain symptoms that the doctor or the physician should be looking for, and if he or she sees those symptoms, then that may be where the malpractice happens if they don't take appropriate action to address those symptoms.
That's exactly right. And in our case, we did not take the position that making the hole was negligent. We said, of course, that can happen even when the doctor does everything right. But like you said, after the surgery, if symptoms start to occur that suggest a hole was in fact made, then the doctor needs to address that quickly, because in that case, all sorts of bad things can happen. The contents of the bowels coming out into the body, causing infection and death, which is what happened here. So in this case, we showed first how a hole can occur during the surgery, but afterwards, we showed, this was an example we used for the jury to show a normal bowel, but then a bowel that could become inflamed because of a hole, and how gas could build up and could not be pushed out the normal way. And so in that case, gas would come back out through the patient's mouth, causing belching. And in our case, we found evidence of a phone call that coincidentally occurred right before the office closed on a Friday, where the patient's husband called and said that his wife had been belching every 30 seconds over and over and over again for hours. And the doctor said it was a complication of the medication that he gave her and told her just not to worry about it. Within 24 hours, she was in the emergency room and unfortunately passed away.
And what this actually was a symptom of a known complication.
Exactly.
Okay.
And go back to our equation board, yes, there's a known danger, which everyone accepts as a risk of the procedure. But if you add that ingredient, ignoring the symptoms of a known danger that the doctor should be aware of and should be on alert for, that's exactly what happened in this case, and it harmed the patient.
Okay. So I think probably the lesson from this case and this example is for plaintiff's attorneys that just because somebody calls them to evaluate a case with a known risk, sometimes the evaluation of that case should go a little deeper. Don't just stop because it's a known risk. Maybe look further and see whether the doctor ignored symptoms that would indicate that there may be a problem or one of those complications that could be treated to save the patient's life or prevent harm from getting worse.
That's exactly right. If you get a case and it happens to be one of the things listed on the consent form as something that could go wrong, I think a lot of people might think, well, that's just the breaks when you're dealing with medicine. But if you dig just a little bit deeper and see how the doctor responded to that known danger, then you might wind up having a case that's well worth taking.
Okay. And I guess on the opposite side, the lesson for our defense lawyer friends that are maybe watching this video is even though it may be a good defense to say that this event or this thing that happened was a known complication, sometimes it's not that simple. And when you're having your experts review the case for you and to prepare your defense, speak with your experts about what happened after the fact and what symptoms were there and how you may be able to explain or defend against the doctor's lack of attention to those symptoms.
That's exactly right. And in this particular case, the jury was very worked up about the fact, not that there was a hole, but that the doctor just became complacent about that known danger and didn't do anything about it.
Okay, so the next thing that we'd like to talk about is the ER statute and whether a patient's care is happening under an emergent care situation versus just a regular hospital setting or a doctor's office can make a big difference in the burden of proof. And so what I'd like to do is ask Marc to give us some more insight on how what's commonly referred to as the ER statute can affect a medical malpractice case.
Thanks, Joel. Well, as a lot of lawyers might know, the ER statute was passed as part of the so-called tort reform package back in 2005. And what that did was it stated that if a patient is getting emergency medical care in a hospital emergency department or in certain parts of the hospital immediately following ER care, that a gross negligence standard applies. And not only does a gross negligence standard applies, but the burden of proof is clear and convincing evidence. As everyone who handles cases is familiar with, the burden is typically preponderance of the evidence, and then you have to prove ordinary negligence or professional negligence. Clear and convincing evidence is a much higher standard. And then gross negligence, instead of what an ordinary reasonable person would do, or a doctor in this case, it means that the doctor is only liable if he or she exercises slight care. So if you're presented with a case that is in the emergency room, one of the first things a person might do is say, I don't want anything to do with this because I have to prove gross negligence by clear and convincing evidence. But there are two parts of the statute that every lawyer who's looking at an ER case should be aware of. And this is in Section C of the ER statute, which is OCGA 51-1-29.5. And the appellate courts have looked at two phrases in this statute that are important for every practitioner to know. The first one was one of our cases. It was the Nisbet versus Davis case. And in that case, the Court of Appeals looked at what the definition of in a hospital emergency department meant. We took the losing position that it depended on the doctor and the orders that were in effect. And in that case, a critical care doctor had actually taken over care of the patient in an emergency room, had signed orders transferring the patient to the critical care department, but her orders were not followed. She did not even make sure her own orders were followed, and the patient stayed in the emergency department for hours and hours instead of being transferred to critical care. We took the position that had the doctor made sure her own order was followed, she would have had an ordinary negligence or a professional negligence standard, so she shouldn't be given the benefit of the ER statute. The Court of Appeals disagreed with us, and the Court of Appeals held that the word in an emergency department, hospital emergency department, means in the physical room itself. So if you are in the physical emergency department, it doesn't matter what kind of doctor is treating you, it doesn't matter what orders are in place, you are potentially subject to the emergency room statute.
So here's a humdinger, because to me, lots of times the devil's in the details when it comes to rules and exceptions to the rule. But one thing that I recently was educated myself on looking at a case was the different triage levels and what triage nurses look at when they're trying to determine what level to triage a patient at. And I believe it's triage level 1 is the most severe, where somebody's basically almost dead, or either they're flatlined and emergency care has to happen right then to save their life. And triage 5 is like somebody comes in to get a refill on their medication, right? They're in the wrong spot. They probably shouldn't be in the ER to begin with. Knowing what the Nisbet case holds, if you've got, say, a level 5 or a level 4 triage patient who doesn't have an emergent care need, they just happen to be in the emergency department, do the ER physicians still get the benefit of the ER statute?
Well, that brings us right to the next component of the statute, and that's a great question, because the statute not only says if care is being given in a hospital emergency department, but it also then focuses on the type of care. And the type of care is emergency medical care. And someone who might just be getting a prescription refilled might not qualify as a person who's getting emergency medical care. And the Court of Appeals looked at that in a case called Abdul Samad versus Daly. It was actually the Georgia Supreme Court. And they held that the term emergency medical care under the statute, under the plain language of the statute, doesn't apply after a patient has been stabilized and is capable of receiving medical treatment on a non-emergency basis. So even though you're in the emergency department under the Nisbet case, you may not be receiving emergency medical care under the Abdul Samad versus Daly case. And in that case, a regular standard of care would apply, and you would not have to worry about the ER gross negligence standard.
Okay. And in those cases where it's borderline, or maybe there's a fact issue as to whether someone has been stabilized, or whether their life, or if they're in jeopardy of serious bodily injury or whatever, is that a jury question, or is that something that the judge will decide as a matter of law?
It typically would be a jury question because it's very fact dependent. And one thing practitioners have to be aware of is if your allegations of negligence are that the patient needed to get care as quickly as possible, then chances are you're also not going to be able to argue that they were not receiving emergency medical care.
It can be a catch-22, and you really have to try to make the best decision, judgment call on how you want to approach your case early on.
Exactly.
Gotcha. All right, so the next thing I want to talk about, Mark, are expert witnesses in medical malpractice cases, and specifically when I'm handling a medical malpractice case, sometimes one of the most challenging things to do is find the best expert for the particular case that I'm looking at, right? Because you want somebody that's credible, you want somebody who's obviously qualified, And if you anticipate they're going to be testifying, you want somebody who's got some charisma about them, and is not necessarily completely plaintiffs-oriented, defense-oriented, that kind of thing. So sometimes that can be a challenge, but if you could just give us some insight on maybe some techniques and some ways that you go about finding credible, likable experts, and also what is required of those experts when you get into pleading a medical malpractice case.
Sure. So finding an expert in a medical malpractice case is probably one of the most important parts, because as most people are aware, under Georgia law, you can't get past summary judgment. You can't even file a lawsuit unless you have an expert who's willing to say that there was negligence, and who also can say that there was causation. And the last thing on earth I would ever suggest doing is getting an expert in a medical malpractice case who tells you what you want to hear. I mean, that applies to so many cases, but in a medical case in particular, if you get an expert who just says, hey, this is my theory, regardless of what medical literature says, regardless of what hospital policies say, then you're just asking for trouble. And given the expense and time involved with a medical malpractice case, you don't want to find out on the eve of trial that you've spent 6 figures on a case, only to find out you have an expert who really isn't very good. What we do in our practice is, first, like so many people, is we keep a bank of experts. We might call friends who've handled similar cases and ask. But in the absence of that, we typically go to the medical literature. And there's a great website called UpToDate, paid service, which has up-to-date literature and articles on practically every aspect of medicine. And what I'll do is I'll just go on and type in the type of issue I'm handling, and it will show at the top the doctors and the editors of that article. I'll click the link, it'll give me their bio. I'll look them up then on Google. Lots of times they are connected with very reputable hospitals, universities, and you can find someone very quickly who is an expert in that particular field. One red flag might be, though, is if they say things that you don't want them to say in their article that you might not want in your case, they might not be the expert to hire. One other thing we try to do is we want an expert who has a lot of great academic credentials, but the last thing on earth you want is someone who's in the ivory tower and has never actually done the procedure. And so we try and strike that balance of someone who might be attached to a good hospital, but who's actually got a very good clinical practice. And that brings me to the statute, is in a medical malpractice case, unlike every other kind of case, you have to have an expert who is actively engaged in the practice of medicine or is actively teaching medicine for 3 of the last 5 years prior to whenever the incident occurred. And if you have an expert who has only done a procedure maybe once or twice, then first you're subject to a motion to disqualify your expert, which then can have your case kicked out on summary judgment.
Good old Daubert.
Exactly. and with an abusive discretion standard with Daubert, if you have an expert who is kicked out on Daubert, then that effectively converts the defendant's motion for summary judgment into one that's going to be reviewed on an abusive discretion standard.
Okay, Mark, so I think it's pretty clear now that we need to look for experts who are not only academically qualified, but also have the real-world experience with their particular aspect of expertise, so that they have credibility with the jury in addition to passing muster under Daubert, because I assure you, if you lose an expert under Daubert, you will also lose probably tens of thousands of dollars along with that expert that you have in litigation expenses. So it's best to do the work on the front end to make sure you have the right person, as opposed to having it come back and bite you on the back end. So now that we know how to go about finding an expert, can you explain to us, once you get into litigation, the affidavit's been filed with a complaint, how do you utilize your expert in the pretrial stage as well as the trial stage when they're going to be actually called to testify in front of a jury?
Sure. So by the time we've gotten to litigation, one of the things we've told our expert is we want to know all the holes in our case. We want you to tell us if we're going down the wrong road. And as we are in discovery and we're starting to take depositions, we will call our expert and say we've got depositions coming up of either the defendant doctor or someone who might have been in the operating suite or what have you, and say, what can you tell us that we need to ask? If it's convenient, we'll go actually meet with that expert and talk about what questions we should ask in the deposition. Sometimes experts are nice enough to even be on call during depositions, where if something comes up that was unexpected, they'll answer it for us. Then, of course, when it comes times for the expert's deposition, one of the big things we try and do is make sure we're up to speed on literature. Because under the evidence rules in Georgia, an expert can be crossed on literature. And we try and find the most up-to-date stuff, present that to our expert, and make sure that they are not going to get caught by contradicting something that is a consensus statement among doctors, or at least that they can explain it. And then finally, before their deposition, we will meet and prepare them just like you would an expert in any type of case. When trial comes, it's very, very important to have your expert ready to go. We typically will fly to meet the expert, and as a side point, we almost always have to fly to meet an expert.
Yeah, most Georgia doctors don't want to testify against another Georgia doctor.
That's exactly right.
I have run into that issue as well.
So we will fly to meet the expert, even if it's only 2 weeks before trial. We will meet with that expert. We will go over our direct examination. We will even show them the visuals we intend to use. We will have the expert review our visuals and tell us whether we're right or wrong. And if they need to make changes, we'll go back to our artist and have the artist make changes. And then we let the expert marinate for a week or so after that preparatory session. Then we will again meet with the expert the night before they testify to the jury to make sure that all questions that they have been answered, that they're comfortable. Never have your expert fly in the day of trial. Always make sure they're there the day before, because the last thing you want is something to go wrong when you're paying someone $10,000 a day to testify at trial and your case depends on it. If you do all that, if you've got the qualified expert, if you've met with them, if you're up to speed on the literature, if you've met with them ahead of time, generally speaking, things should go as well as possible at trial, and we try and keep that scenario in mind all the way through the discovery process.
All right, those are good points, and I'll just add that with medical malpractice cases, one of the biggest deterrents for a plaintiff's lawyer to bring the case is, number one, the expense. It's just like products liability cases as far as experts go, and experts aren't cheap. So if you're going to venture out into the world of handling medical malpractice cases or products liability cases, just be sure that you factor into the case, into your thought process and evaluation, what it may cost to get this case to trial. Because it is indeed the rare event where you have a medical issue that may or may not be malpractice, and the defense just rolls over and says, oh, here's $1 million, we're not going to fight you over this. It does happen, but that is the exception to the rule. And also be aware that just the evaluation of medical malpractice cases can get expensive, because when you're looking at something, I have literally had some cases where it just seemed to me to be clear as day malpractice, and I send it off for expert review along with a $5,000 retainer check for this expert, only to get an email back that says the doctor provided excellent care, there's no malpractice, and there goes the $5,000. Thank you, Mr. Expert.
And that expert might have also saved you $150,000 by doing that.
That is exactly right. So that's why it's so important to go through and put the time and effort in to begin with. What I would encourage you to do, if it's your first time looking at a medical malpractice case, I would highly encourage you to reach out to somebody like Marc that can help you. We all started at some point and we had to learn how to do it somewhere, but a medical malpractice case is probably not one that you want to go it alone on your first time or even your second time. Bring somebody in like Marc. And even though you may be splitting fees or something like that, it would be well worth it, and it will increase your chances of winning your case. If you're a defense lawyer, look out for this guy. He's pretty good. Speaking of defense lawyers in this state, I think the medical community is very fortunate, because there are some excellent medical malpractice defense lawyers that make our jobs more difficult than they may be in other states. So shout out to the lawyers, some of the common names, we all know them, that do medical malpractice defense, because by and large, I have found, at least in my experience, that they are formidable foes, and for the most part, above board.
That's our experiences with the defense lawyers in Georgia. It's always a mixed blessing. You're going against some of the most qualified, experienced lawyers in the state, but also some of the best, most above board and honest lawyers.
That's right. Okay, guys, so if we've gone over quite a bit today, this video is going to be posted on our YouTube channel. If you like it, if it's been helpful to you, we appreciate you liking it, sharing it with your friends or your peers. If there's anything that you think you can add to the information that Marc has provided to us today, if you'll just enter that comment down below. If there's anything you disagree with, we'd love to hear it, because dialogue makes us all better lawyers. So anything that you can add or point out that may be correct or incorrect, just put it in the comment section below. And that would be great and very helpful to us, as well as your fellow members of the bar who may see this. If you are looking at a medical malpractice case or thinking about getting into that field of practice, I encourage you to reach out to Marc. Marc, how can somebody get in touch with you if they'd like you to look over a potential med mal case for them?
We'd love to work with anybody who's looking at a medical malpractice case, and we can be found on the web at popehoward.com. Our phone number is 404-885-9999. And my email is mhoward@popehoward.com.
All right, sounds good. Well, we hope the information that you've gotten in this video has been helpful, and we look forward to bringing you another video on a topic very soon.